any of you have clients who are wanting to watch, this is the same. My YouTube stream is always, well, what we see, the content's not always the same, but the link is always the same if you have previously shared that with your clients if they want to watch. All right, we will get started. It looks like we've got everyone here, I think. Yes, all right. The court will call Coke County cause number CV 04622, styled Carol Lee and Peggy Lee and others versus Memorial Production Operating and others. We have all of the council present this afternoon, it looks like. And just for the record, I know y'all are aware that I do this, but I hold all of these hearings, even if they're on Zoom. I hold them from a courtroom that is open to allow for public observation. At the moment, the only people who are present are myself and Ms. Wilding. And then we have Ms. Jennings, who is filling in for OCL as my bailiff today. And I am also live on YouTube. All right, we have a number of things. Y'all are burning the midnight oil clearly. Seems to me the first thing we should take up is Defendant Granfield's motion to reconsider. And so give me a moment to get to a blank spot on my pad and we will get going. Who did we just lose? Anyone tell? Is everyone still here that we need?
We lost whoever SH is.
Okay, I think that may be Ms. Oscarson's paralegal.
It is, Your Honor, and I'm not sure, maybe she went on YouTube, but nevertheless, we can proceed.
Okay, all right. Give me 1 second. I have this newfangled device that I take my notes on, and I can't seem to get to the end of the notes on this case. I'm trying to go paperless with my notes, and now. All right, we are ready. Mr. Terrell, you may proceed.
Yes, may it please the court, Your Honor and counsel. Your Honor, I'm not going to belabor the court with a long argument on this. You've heard a lot from us regarding this matter, but the essence of our motion to reconsider is the fact that the plaintiffs now have made a judicial admission that CC Forbes on December 20th and 21st of 2010 were not responsible for placing a second illegal or double E packer in the well at 261 feet. And Your Honor, based upon the evidence in the case, and I think by implication, the question becomes then, is there any evidence in the record, or more than a scintilla of evidence in the record, that Granfield, other than CC Forbes, conducted an operation on the SWD number 5 after the CC Forbes crew left on the 21st, or even if somehow or another Granfield went out on the 20th and did some additional operation installing the double E packer. And it continues on out from there for the reason that, is there any evidence in the record, has plaintiff come forward with any evidence that any time up in time of the change of operation between Granfield and Ivory did Granfield, is there any evidence that Granfield came out and had another service company or put this packer in the hole? And I don't believe there is. There's been a lot of argument, a lot of discourse regarding this motion to reconsider, but the plain fact of the matter is there has to be evidence. And they have said, well, we've got a.
Oh, hold on, we just lost you, Mr. Terrell. Mr. Terrell, can you hear me? All right, we have lost.
Ma'am, I can. Hear me?
You are breaking up on us. You're back right now. So give it a whirl, see if we can make progress.
Okay, I'm sorry, Your Honor. This thing has just been, I don't know, some days it works and some days it doesn't. But what I was talking about, no evidence that Granfield, other than CC Forbes, performed any operation on the SWD number 5. And therefore, I think the motion to reconsider the summary judgment should be granted. And that goes further. We were talking about, is there any evidence of causation or damages as a result of any activity or non-activity of Granfield? I was involved in other part of the argument when I faded out. Now I'm trying to remember where I was going with that, but all of the I know where it was. The plaintiffs had filed a supplement regarding their response, saying Lee Beam testified that Granfield had a workover unit. Even though that is not correct, he did say that, but he didn't say that Granfield used it. So simply the ability, perhaps by Granfield, to have a workover unit is not evidence that Granfield used it or installed that packer. There simply is no evidence. And that Your Honor, is our argument regarding same and how it impacts adversely Granfield because of the judicial admission. Now, everything that related back to CC Forbes working for Granfield December 20th and 21st, now the plaintiffs say, well, no, that didn't happen then. Well, when did it happen? And where is the evidence that Granfield caused that to happen or was involved in that happening? And Your Honor, I won't belabor that anymore. We filed probably 200 pages or more of documents regarding that.
All right. Thank you, Mr. Terrell. Mr. Knight.
Thank you.
May it please the court, Your Honor. There is evidence. Candidly, the problem is how it appears Granfield is defining evidence. Evidence comes in both the form of direct evidence and circumstantial evidence. We have both here. And the other implication of Granfield's argument is that unless a defendant stands up and says, oh, you know what, I did it, then purportedly there's never sufficient cause to get to the jury. We don't need that here, though, Your Honor, because the evidence is this. First and foremost, a double E packer, as a court knows all too well, probably painfully well at this point, was in fact pulled from the well. There's no question that it had to be done sometime. We also have, as the other critical bookend, and I've used that term more than I would have liked at this point, that by June 1st, 2011, Ivory representatives have testified under oath that they were correctly documenting the location of that double E packer at 261 feet, almost 3 years before the well was physically opened and it was removed, which means the well had to have included the packer prior to that point. Ivory, in no uncertain terms, has said, we did not install it. There is no circumstantial or direct evidence that Ivory installed it. We have, additionally, Your Honor, attached to our response, the deposition testimony of Mr. Baltazar, who, on behalf of CC Forbes, testified, we opened that well on December 20th, 2011. There was no double E packer in it when we opened it. And when we left, there was no double E packer. So that evidence, Your Honor, removes any dispute that the double E packer got installed between December 20th, 2011 and June 1st, December 20th, 2010 and June 1st, 2011. The only two operators during that time frame were Granfield and Ivory. There's no evidence that Ivory did it. That leaves Granfield. And so if Mr. Terrell and Granfield are suggesting that when we put on elements of this caliber to a jury, that they're going to say, although the direct evidence eliminates anybody else and leaves only one defendant, who we now have testimony reflecting they actually had the capability to do it themselves, Mr. Botts. That's designated deposition testimony that is in the record. No one has objected to it. It will be presented at trial. If Granfield's position is, okay, we're going to dispute whether or not that is true, they can do that. But when one person says X happened and the other person says X did not happen, that creates a genuine issue of material fact that only a jury can resolve. There has never been any question in this case about what happened, a double E Packer was installed in the well, or when it happened between December 10th, 2010 and June 1st, 2011. The only question was who installed it on behalf of Granfield. At the beginning of this case, everybody, including Granfield, thought that CC Forbes was the person who physically installed it. We've now ruled that out because we have exhausted, as we had an obligation to do on behalf of our client, every possible mechanism to determine if it was in fact CC Forbes. But that's just a who. It's not the what, and it's not the when. It still happened, and all evidence, direct evidence, excludes anyone from doing it except for Granfield. And the other issue, Your Honor, that we've pointed out, because Granfield arguments now, I think, heighten this concern in our response. They unquestionably performed the state-required 5-year test on December 27, 2010, 7 days after the well was opened. They then filed and attested to, under penalties of perjury, the truth of that H10. And they filed it with the Texas Railroad Commission on December 10th, 2010. And that's attached to our response, Your Honor. I'll give the court the exhibit number. I won't share screen it. As a part of exhibit number 7. December 27th, 2010 is when the test was run. December 29th, 2010 is when Granfield, under penalties of perjury, filed that document with the Railroad Commission. What we know from Mr. Baltazar's testimony is that when CC Forbes left the site of the SWD5 on December 20th, they left 9 joints of tubing, approximately 31.5 feet in length each, sitting on the surface. That means that well was approximately 200 to 300 feet above where it would have been legal for the base of the tubing string to end. So if Granfield is now saying, oh no, we didn't put the tubing back in the well with the Packer on it, which is what their expert, Jeffrey Hughes, says had to have happened here. If they're saying, no, we did not put the tubing in before we ran that 5-year test on December 27, 2010, then that in and of itself is another falsehood, because they falsely represented to the Texas Railroad Commission that they were testing down to a tubing string of 4,400 feet, when on this record, it would mean that the base of the tubing was at approximately 3,400 feet, which Jeffrey Hughes has testified in and of itself would have been legal. And Your Honor, this is the issue when somebody is being untruthful. No matter how many times they try to adjust their story, they're going to run into some objectively insurmountable difficulty with their position, because it's just never going to add up. And that's what's happening here. No matter how many different ways Granfield tries to position itself to suggest that, oh, it couldn't have been us, or oh, there's some uncertainty as to whether or not whether it's us, they run into the same problem, that their conduct violated Texas Railroad Commission rules and regulations. The last thing I'll point out, Your Honor, and we pointed out in our briefing, when Granfield's representatives were put under oath and given an opportunity to simply categorically deny that the double E Packer was installed during their operations, irrespective of who may have done it, but to just categorically deny, say, no, we didn't do it. I'm sure we didn't do it, the way that Ivy did, for instance. They always hedge their answers because they cannot put forth any affirmative evidence to rebut both the direct evidence and the circumstantial evidence that we put in the record that establishes there was nobody else who could have done it but Granfield. That is more than enough to entitle us to reach the jury on our claims against Granfield. So we request that the reconsideration motion be denied.
Your Honor, before Mr. Knight ends, there was one other point. Roger Herring, the corporate rep for Ivory, is the person who created the wellbore diagram. And at the bottom of the area that goes to maintenance and workovers, there's an entry for the 12, 10, 20 activity. And I asked him, where did you get the information that talks about that entry, that talks about the 8 joints, that talks about the packer to put on here? And he said, I got it from Granfield. Based on Mr. Herring, Granfield knew all about that and told him, and it made it to that document. So there's clearly a fact issue based on that admission. And I just wanted to add that in closing to the other points that explain why this should be denied.
All right, Mr. Terrell, I'll give you the last word.
All right, Your Honor, that last statement by Mr. Addison was an omission by Ivory and not by Granfield. But regardless, the plaintiffs are limited by their pleadings, and the pleadings they have said in 70 pages. Granfield conspired with C.C. Forbes to install an illegal double packer and fake an H5 test about 5 days later. Those are the pleadings, and those have not changed until they settled with C.C. Forbes, and now they've changed their story. They haven't changed their pleadings, which they're still limited by. It's still argument. It's not evidence. It's not even circumstantial evidence, and they're using wellbore diagrams. And this is the problem I was telling the court the other day. The problem with changing your story 10 days before trial is now they're saying, oh, C.C. Forbes didn't do a thing. However, the wellbore diagrams, all created by someone else, not Granfield, all created at least ostensibly June 1, 2011. Even the plugged and abandoned well is dated June 11th, 2011. I think Mr. Brill said it best before I was in the case. Unless someone's clairvoyant, somebody is creating these wellbore diagrams after the fact. And more importantly, in those wellbore diagrams that have E.E. Packer 8 joints down, that is almost an exact quote out of what everybody has been misinterpreting under the original Raul Baldassar field ticket that said came out of the hole, went back in, and they said put a plug on it. They were saying that is the E.E. Packer. Well, now they're saying, no, we were wrong about that. And if they're wrong about that, they're wrong about Granfield as well, unless they show the court some evidence. And Your Honor, you know for a fact, in being involved in these cases, had they had that evidence, they'd be running to you and showing it up on the screen and hammering everybody with it. They simply don't. Their evidence is that Ivory's admitted that at some point in time after they took over operations, they were aware. And you know, that is what Ivory has said. However, these wellbore diagrams are under some scrutiny, I would say, in this case, as they're all dated June 1, 2011, and that's impossible. So their evidence is argument and not anything more than that. Thank you, Your Honor.
All right, thank you. Let's move on to the next issue. The next thing that I see that I have on my list for us to address is plaintiff's motion to amend. Plaintiffs are seeking leave of court to amend their petition. Who's handling that for plaintiffs?
I will, Your Honor.
Right.
That is frankly a contingent request. We fundamentally disagree with the notion that the way that the causes of action are veered somehow categorically preclude us from presenting the evidence as the evidence has been developed, and as frankly, I don't think anybody disputes. What you have not heard here is anybody suggesting, oh no, C.C. Forbes did do it. Nobody's arguing that. We've taken depositions, we've questioned individuals, we have deposed experts, most recently Jeffrey Hughes, less than 30 days ago, I believe it was September 18th, and Jeffrey Hughes, when questioned by Mr. Addison, he stuck by his story and his analysis, which we candidly think is sound, about what happened here. That CC Forbes pulled the tubing, CC Forbes left the tubing at surface, but it had to have gotten back into the well before December 27th, 2010. And the only person who was operating between that time frame was Granfield. So the notion that the auto date on certain later version, there was no auto date on certain later versions of the wellbore diagram to update when there were later modifications made, that somehow calls into question the authenticity of a document we've had two people attest to. We don't think that any of that's credible. And the reason that's important relative to this amendment issue, Your Honor, is it again goes to the fact that we know what happened here and we know when it happened. In our original petition through the Fourth Amendment version that we're on now, we averred what happened and when it happened. The only thing that proved to be incorrect was who specifically installed the double E packer on behalf of Granfield. Everybody, including Granfield, who once admitted it before they then moved this court to withdraw their admissions that it was CC Forbes. Everyone at the outset of this case perceived the fact that it was CC Forbes who installed the double E packer during Granfield's operation. Well, just because we've now concluded, everyone, that no, it wasn't CC Forbes who installed it, doesn't mean that it was installed, because we know the answer to that. And we also have the timing bookends. So our claim in causes of action against Granfield has never been contingent upon if it was CC Forbes specifically who installed the double E packer. Our claim against Granfield, and I want to be clear on this, our claim against CC Forbes was based upon our good faith belief that Granfield once shared, that it was CC Forbes who did it. But after we exhausted any ability to confirm that through evidentiary record, we did what we, I think, are duty bound to do in the law. You let CC Forbes out of the case. But as to Granfield, our case against Granfield has never been contingent upon if it was CC Forbes specifically. It was contingent upon this happened during your watch. And here's the direct evidence, here's the circumstantial evidence that establishes it happened during your watch. Not a single thing about our case has changed in that regard. So our position is, based upon, we cited, for instance, the Brown versus American Transfer case, this is a Texas Supreme Court case from 1980, that talks about, look, unless we're talking about some substantial misleading, unreasonable surprise or prejudice, you don't have to amend. Because it's never going to be the case that after a case has been pending for 5 years, even with intermediate amendments, that the proof at trial is going to be perfectly identical to the averments in the complaint. And when there are deviations, the Texas Rule of Civil Procedure says, well, the appropriate recourse is a trial amendment. So our position is an amendment is not even necessary. But if they are suggesting that unless every single word in the live pleading aligns with every single nuance of the evidence of trial, then we respectfully request for leave to resolve our position, because this is not about prejudice or unfair surprise. Their expert came up with exactly this theory almost a year and a half ago. We had the right to depose that gentleman and to ensure that his theory, in fact, was going to stand up under scrutiny. But it's fundamentally their theory from their expert, which our expert looked at and said, you know what, we agree. This is right. And I'm going to articulate through a supplementation in my deposition, as I'm allowed, I'm going to articulate that this is right. So there's no unsurprise, there's no prejudice here. This is everyone looking at the evidence and drawing the conclusion that's allowed by the evidence. But from a technical standpoint, if we need to amend, then we respectfully, in an abundance of caution, request leave to amend our petition to address this singular issue.
Right. Is it Mr. Terrell? Who, if anyone, wants to respond on this?
I think probably Mr. Terrell and I would like to respond on it, Your Honor.
All right, Mr. Terrell, you go first.
Okay, thank you, Your Honor. I will say this regarding the pleading amendment. When C.C. Forbes was the only field operator on the SWD number 5, throughout this case, at least since I've been involved, and I did start in the case late, but for the last year and a half, the total topic regarding whodunit was that C.C. Forbes was the only operator on the well on December 20th and 21st. And there was not another operator, not another field ticket, not another operation while Granville was the operator. And I don't even know if there was one with Ivory. And so when I deposed Colonel Foster, I asked him and went through some of the Baldassar testimony, and Your Honor, to be clear about this, the responses have been very critical of Granville and are being disingenuous with the court. We are not at all, because I think if you saw that blurb out of Colonel Foster's deposition, I asked him, have you now changed your opinions regarding what you said in your report, in your detailed report? And he goes, I have not. And at the end, I said, well, but if Raul Baldassar is telling the truth, then you would say that C.C. Forbes did not install the double E packer. And he said, well, if Baldassar is telling the truth, or if you believe Baldassar. So now we have designed, at least this defendant has designed its defense from the December 20th and December 21st workover by C.C. Forbes. And the idea that C.C. Forbes and Granville conspired to put in a double E because it wouldn't pass a pressure test and then fake the H5 test. And so when the plaintiffs now have settled with C.C. Forbes, no longer do they want to blame C.C. Forbes. However, the defendants now have to change, and they can't change. We have our expert opinions. We have our expert reports. We prepared for this and now when they've changed their theory of the case, then we have no ability to really respond. So Foster hasn't changed his opinion as far as I know. Of course, the court has entered some orders in that regard, which cover some of that, but not all of it. And, you know, that's our belief that it's unfair prejudice to the defendants now after a year and a half or 2 years and thousands of dollars of testimony that the plaintiffs now are changing course.
All right, Mr. Brown, let me you respond.
Thank you, Your Honor. We're picking a jury Monday, and we've been getting ready to pick that jury based upon their fourth amended petition. We don't even know exactly what they're seeking to change for, but I will say that we're prepared to try the case on that petition. I will also say that C.C. Forbes is a settling defendant. They stated that they felt they had to let C.C. Forbes out of the case. They were duty bound, I think he said. They were duty bound after they paid him $315,000 to settle the case. They're a settling defendant, and they will be submitted to the jury. There is circumstantial evidence that, in fact, C.C. Forbes did install that packer. Mr. Terrell touched on some of it, but they're the only workover rig that we know of that was out there in that time frame. So they're the only one we know had the capability. Yes, it's contrary to Mr. Baltazar's testimony, but they had the capability to do it. They were out there. There will be evidence, questions asked about their potential to have done it. There will be sufficient evidence to submit them to the jury as a settling defendant. And this attempt to change, and obviously what prompted this is they've settled with C.C. Forbes. It no longer behooves them to blame C.C. Forbes. That doesn't prevent these defendants from blaming C.C. Forbes, and it doesn't give them the right to amend their petition when we're all about to get in our cars in 2 days and drive to Coke County, Texas to try this case, and not knowing what we're going to be trying it on because they're about to change their petition.
All right, Mr. Terrell.
I have nothing further, Your Honor.
I'm sorry, I meant Mr. Knight. I looked at the right person and said the wrong name. I'm so very sorry.
Your Honor, could I express Ivory's position, please?
Yes, you may.
Just for the record, I don't have much to add in the way of argument, but I do want the record to reflect that Ivory is opposed to plaintiffs amending their petition at this late date. And now I'll let Mr. Knight respond. Thank you, Your Honor.
All right, Mr. Knight.
Yeah, I'll take these up in reverse order. Mr. Brown just said there is circumstantial evidence that CC Forbes did it. Okay, so if that's Memorial's position, Memorial is reinforcing the fact that Granfield is not entitled to summary judgment. Hard stop. Because this all converges on the fact that this is not about whether it happened or when it happened. This is only about who specifically did it on behalf of Granfield. In fact, what it seems like Mr. Brown is arguing is not anything that has to do with the issues that are put in play by Granfield. He's talking about the Texas Civil Practice Remedies Code allocation scheme and their position that they want to put on evidence that CC Forbes did it. Nobody's raised that issue here. That's not currently before the court. If they want to make that argument, which again is going to, I think, narrow squarely back to Granfield, well, we'll cross that bridge when we argue the jury charge. Because the Civil Practice and Remedies Code does say you only get to include an allocation if there's evidence to support doing so. And so if now they're saying they're going to put on the case saying CC Forbes did it, well, we'll take up whether or not the evidence actually bears that out. But that has nothing to do with whether or not Granfield should or should not be entitled to summary judgment, because they're not. It further emphasizes why they are not. Now, as to this notion that any of these defendants purportedly can't figure out how to defend the case now based upon this quote unquote change is really peculiar, because it is Granfield's expert, Your Honor, I reiterate, Jeffrey Hughes, who has articulated precisely this opinion. He did so in his expert report. We've attached that as an exhibit. He has done so, Your Honor, in the deposition testimony he gave less than 30 days ago, which has been designated and not objected to for inclusion in the trial record. So I do not understand, candidly, how a defendant can say, heavens be, I don't know how to defend this case, when the case in its current posture is reflective of what that same defendant's expert has said happened. So I respectfully submit that that's disingenuous, Your Honor. To the extent, however, that from a purely technical standpoint, an amendment is necessary, and we do not believe that it is. And frankly, Mr. Brown, I don't think he's made an argument as to why it is. If he wants to argue his defense based upon evidence he thinks he can develop, Memorial thinks he can develop it, they should argue their defense. That has nothing to do with summary judgment. It has nothing to do with whether or not a pleading should be amended from a purely technical standpoint to align with what we frankly think the evidence is going to show. So we respectfully submit that if this is an issue, we be allowed the opportunity to amend.
All right. Anybody else have anything they want to say on this issue?
No, Your Honor.
All right. Very good. Then here are the court's rulings on the motion to reconsider. The court's opinion that the jury, as the fact finder, will be the sole judge of the credibility of the witnesses. That includes Mr. Balthazar, and of the weight to be given to their testimony. And therefore, the motion to reconsider is overruled. As to plaintiffs' request to amend their pleadings, this case has gone on since 2016. I understand y'all have only taken expert depositions here in the last few months, but that deposition with regard to Balthazar was taken quite a while back, because I heard early on, I think my first hearing on this case was the motion to withdraw the admissions on, that was Granfield's motion. Balthazar's testimony was the key issue in connection with that motion. Therefore, if plaintiffs wanted to shift gears, they've had plenty of time. Plaintiffs' request to amend their pleadings, for leave of court to amend their pleadings, is denied. All right, now let's go on to, do we still need to take up, Ivory had filed a motion to compel production. Ms. Oscarson, is that a matter that still needs to be addressed?
Your Honor, Mr. Knight emailed me shortly before the hearing began and said that plaintiffs are going to produce those tax returns. So no,
Okay.
we do not need to take that up.
All right. What is the timeline, Mr. Knight, just so we have it on the record that you will be producing those tax returns to the defendants?
I think I will very likely produce it by the end of today, certainly by no later than tomorrow.
All right. Excellent. Can we say noon tomorrow at the latest?
Certainly, Your Honor.
Right. I'm happy to sign an order to that effect if you would like one, Ms. Oscarson, or counsel has, of course, made that representation on the record. All right. Now let's go to, but I think let's first take up, by the way, thank you all. The joint exhibit lists and the way y'all have put together these charts, that is exceptionally helpful for me and for Ms. Wilde to know what is agreed and what we do need to take up today. So thank y'all, and thank you paralegals for all that hard work. I know how this works. They often don't get much of the credit, and they are, and only Ms. Oscarson's is on the line to hear that. But
I have to tell you that Mr. Burrell was my paralegal and everybody else is paralegal on that
Yeah.
task, Judge. So he gets the credit for that.
Yeah, I wanted to echo that. Mr. Burrell carried the laboring aura of this, and this appeared full blown and grown to us, and it was helpful.
well, it is very helpful to the court, and thank you, Mr. Brill. All right. So what I have not had a chance, because I have printed these just shortly before coming into this hearing today, it looks like what y'all done is y'all will have defendants numbered exhibits and plaintiffs numbered exhibits. And we need to go through and address, do y'all want to address objections on these now, or do y'all want to simply address those at trial as exhibits are proffered?
Your Honor,
Your
we
Honor.
already have the list, so I think it's better to do it before trial, time of trial. We just have this list sent out. I don't know that anybody's had the opportunity to really go through it in detail.
And Judge, I'll join that. I think our notes are correct. I think we did it right, but we probably sent it to plaintiffs too late for them to go through and make sure we didn't make a mistake. There are some exhibits that will probably dovetail with some of the motion and limine issues that we'd probably like to know the court's thoughts on them before opening statements. Maybe not. If we know you're not going to let it in, we won't talk about it. But I don't want to talk about it and get in trouble because you don't let it in. So.
Absolutely. Okay, well then let's do this. Let's go to motions in limine. And obviously we can take up, my hope is that we will get our jury seated and we will still have time left on Monday for all of us to do some additional pretrial work. At that time, we can address the exhibits if y'all want to take those up then. Let me see, give me just one moment. Tanya, would you get me all of I think we created a stack that was all the motion and limine issues. All right, thank you. And let me see, do we have the motions in limine? Are there some? All right, let me tell you what I have here. I have Ivory's motion in limine and incorporated order. I have Granfeld's reply brief in support of motion in limine. I have Memorial supplemental motion in limine. I think I should have, what I may need, Tanya, is there's a couple of these binders that I may need to have their original motions in limine in them. Let me give you, there's that one. Let's see, what is the one that has the yellow cover, the highlight on it? Okay, let me see what that one is. Thank you. Let me hand you this. This can go over there. Let's just set that over there on the jury rail, if you don't mind. That one I don't need yet. Get to my morning's version. Thank you very much. need probably Granfield's original motion limit, and I may need plaintiffs also. Thank you very much. All right, who wants to go first?
May I make a suggestion?
You sure may.
I actually think that where we're going to end up on the amenities by and large is going to be very similar to where we ended up on the exhibit list. We have been working, I know we informed the court the last time that you guys had a hearing that we were working on it, and we're getting closer to the point where we can cross out quite a few of them. I know there are going to be some that the defendants primarily going to want to talk about today. And so my suggestion is plaintiffs think it highly likely that to the extent they have any left, they will be few and far between. And so perhaps we should table that. Defendants in certain respects may want to take a similar approach, and then just discuss the ones that my sense is are more meaningful to them today.
Okay, that is fine. At some point, I will need someone to let me know what all are agreed, and whether it's a mutual to everyone. I mean, obviously there's some standard ones like insurance and settlement negotiations and all of that that we all know will obviously come in. So at some point, y'all let me know that. I am fine if what y'all want to do is have that in a list, almost like you did the exhibits, but that may be too burdensome. So y'all figure out what's the best way on that. But let's address if there's any, so the plaintiffs don't want to go into your motion in limine today because you think y'all may get some resolution on that. Let me then turn, the one that I have on top is memorials. And so Mr. Brill or Mr. Brown, which ones of y'all's motion in limine do we have that need to be addressed today that there is not an agreement on?
Judge, it might be the opposite situation, that the ones we need addressed are some of the plaintiffs' liminees.
Just hold on 1 second. What is that black notebook? Let me see if that's plaintiff's motion in limine. Thank you very much. Yes, that's what I need. All right, so what I have in connection with plaintiff's motion in limine is I have the motion in limine filed by plaintiffs on September 29th. I don't see that there's any amended or additional or supplemental. Am I right on that, counsel?
That's correct, Your Honor.
Okay. All right. Then which ones, let's do this. Go through, let me just get y'all to let me know which ones there are that any defendant has an objection to that we will need to address. So number one, does everyone have plaintiff's motion in limine in front of them? All right.
Yes.
Any defendant unwilling to agree or unable to agree to number one, blaming other persons, not a defendant or a responsible party?
Ivory objects.
Okay, so Ivory objects to that. All right. Number two, harm or responsibility.
Ivory objects.
Okay.
So does Granfield.
Okay. Number three, financial services.
Granfield does if, depending on the other rulings of the court regarding what damages are in issue for impeachment purposes, and maybe not if the court rules a certain way regarding plaintiff's damages.
And
Okay.
Judge, we do have a problem with the number 3 and number 4, which are both financial. But I think we also would like to get rulings on our supplemental motion that we filed yesterday that deals with the damages. But 3 and 4, we do have issues with.
Let me first make sure, because obviously we had some email problems and I want to be sure y'all got, did y'all get the court? And I am sorry, I just can't remember if I've signed an order on it yet or not. I know that I sent a ruling out. Yeah, are the damage issues y'all are wanting to bring up are over and above the court's ruling in connection with damages on summary judgment, correct?
I really don't Are they?
It's,
Plaintiff,
well, I'm
proceed.
not sure it's over and above it, Your Honor. I
Yeah.
think we disagree, the parties disagree on what the order says.
Okay,
And so we're going to need some clarity from the court. Some of it may come through this lemony process.
that is just fine. I wanted to be sure that number one, it may have been confusing, but and I will certainly try to help clarify that if I've made a ruling that no one can figure out what in the world I've said. It unfortunately wouldn't be the first time. Usually it's in family law context. No one can agree on what I've just said you can and can't do with the kids. So anyway, but we'll dig into that. I just want to be sure that I had actually gotten a ruling out, confusing as it may be. So we'll work on clarifying that. So, okay, 3 and 4 will need to be addressed. And then 5, equally available witnesses. Do we have an objection to 5? All right, so 5, we don't have to address. 6, stipulation requests. That's pretty standard. Anybody have a problem with that one? All right, good. Mediation, obviously not an issue. Effective jury's answers. Anyone have a problem with that one?
Ivory doesn't have a problem as more of a clarification. It says that the parties may not present evidence or argument that would tend to inform the jury. If would tend could be left out and that informs the jury. I just don't want to get in trouble in argument if I'm going through the charge with the jury and I say something that would tend, but I don't tell them, if you don't answer it this way, plaintiffs will lose or win.
Any response?
Plaintiff has no objection to that, Your Honor.
Okay. All right. Any other defendant have a concern with that modification that it would be the parties may not present any evidence or argument that informs the jury or the jury panel of the effect of their answers to the questions submitted? Anyone have a problem with it now as it would be written? All right, excellent. Number 9, payment of damages. As to how the damages would get paid. Pretty standard. Anybody have a problem? Okay, excellent. And then discovery objections, that should not be a problem unless I'm missing something. Okay, all right. Plaintiff's counsel's law firm, that there's no one. I don't see, since we don't have, this is not big city versus someone local. Anybody have a problem with that? I presume Houston lawyers don't want it to be said.
We just don't want to be called Dallas lawyers, Judge.
Well, believe us, we don't want you to be.
All right. I think where the firms all are located may already have been given to the jury in the questionnaire. I mean, so, but I understand. I know it's not, I don't want to be the treated like you're David and Goliath. All right. Counsel's opinions, there shouldn't be a problem with that one. All right. Settlement negotiations, obviously not a problem. Other lawsuits, number 14. Anyone have a concern on 14? All right. Very good. 15, level of sophistication of plaintiffs or their agents. Anyone have a concern about that one?
Your Honor, I have maybe more of a question. The case that they cite has to do with fraud, and the court's already ruled on the motions for summary judgment with regard to fraud, so I'm not sure that this one applies anymore.
All right, let me put it this way. Is there any reason that counsel couldn't approach the bench if you wanted to go into something that went into this territory? Sounds like it may not even come up.
No, Your Honor.
Okay. All right. Number 16, plaintiff's private property. Any?
Your Honor, I had a question on that based upon Merrill Swanson's deposition we took last week, I believe, and there's likely an issue, a discrepancy in acreage between what Merrill Swanson testified as the appraiser, some 1,900 acres, and what our expert or the records may show of some 1,600. So there was a question on who owned it or what property it was and how did he get included. So that was my question about number 16.
All right, plaintiff's counsel, any clarification on that?
We're happy to modify the language, Your Honor. The modifier that we thought got us there was not directly involved in the case. And my sense is any property that would be of interest to Granfield would be property that falls within the involved in the case. But on this, as well as others, I frankly think that we probably would be, if given more time, save the court from having to babysit us on this, on the rest of these. But
Really, all I'm trying to do is figure out what we need to fight over. And I'd like to get those that are not agreed heard, or that are critical for y'all heard today. And I don't have anyone jumping up and saying, Judge, we need to address this issue. So if someone wants to take the lead, I'll quit going through this line by line.
Judge, if it would be helpful, I had quite a long call with Mr. Addison, and we went through our objections to his.
Okay.
Which are very few and far between. I've not had the same conversations, but I suspect that Ms. Oscarson or Mr. Terrell can jump in and tell you the ones they objected to as well after I do mine.
And I guess the other thing, Your Honor, yes, I did talk with all three, and my attempt to synthesize all that information didn't make it to everyone else. Although in synthesizing it, almost every one of these generic motions in limine were agreed to, certainly by Memorial and me, and I'm holding the version of Granfield's. And as you walk through the rest of ours, I think that after number 16, we agreed on all of those. So I kind of echo what Mr. Knight said, in that if it's coming down to do we take up the court's time, I think by Monday, when we take up the exhibits, we might be down to 7, 8, 9 of these is all, cumulatively. There are 3 or 4 that everyone has alluded to that have a tremendous impact on where the case is headed.
All right.
And maybe we should just take those up, and the council will take on the responsibility to get the court a synthesized list either Monday when we meet or prior to that time.
That's great. What I want to do is anything, because I don't have any time left until Monday morning on my calendar. So anything that y'all need a ruling on before jury selection, let's address right now. Anything else we can take up Monday. That is not a problem for me at all, because I know y'all have lots more work to do. Well, just to get ready.
No, that may be an understatement.
All right. So which motions in limine, just point me in a direction of whose motion and what issue do we need to address?
Judge, I would say for Memorial that plaintiff's motion in limine number 3 and number 4, and both of the supplemental motions in limine filed by Memorial, I think would probably give us all a lot of information on where we're going from here.
Okay. All right. Then let's take up plaintiff's motions in limine 3 and 4. And it sounds like this all has to do with the damages ruling. So financial services and other ventures. All right, guys. Defense counsel, tell me what your concerns are.
There's 2 areas of concern I have, and I won't speak for the other side, other defendants, but first area of concern is that the plaintiffs have filed, and I'm going to call them banking documents generically, which give valuations of this property both before and after this incident. And I believe that numbers 3 and 4 might be broad enough that they would prevent us from going into putting those into evidence. And in a call earlier this week, I suggested that we redact everything that they don't want, but at least have the first page of the financial document, or Mr. Terrell suggested this, the first page of the financial document, and where they actually make a representation to the banks as to the value of the property. If these 2 would knock that out, then I disagree with them. There's another issue with the tax records they have that are supposed to be produced tomorrow. And I think Ms. Oscarson was probably the one most concerned with that. So I might defer to her to discuss those issues.
Okay, let me first go to the bank records. Sounds like this is where plaintiffs may have used this, listed this as some type of an asset that a bank was considering in a financial statement. All right. In connection with the representations made by the plaintiffs to their banks as far as what this land was worth, before and after, why should I not deny this motion to eliminate? Plaintiffs' counsel.
If we were taking that position, you should deny it, Your Honor. We're not taking that position. The redaction methodology that Mr. Brown just talked through is probably going to be the practical way to deal with it. We're talking about weight and import to be given to that evidence, and we'll deal with that in the context of the trial as opposed to some kind of categorical exclusion.
All right. So sounds like we don't have a problem with those representations being admitted with other information being redacted, which certainly makes sense.
And Your Honor, provided that they're not going to go get into all the other activities the Lees are involved with. This is much broader than that narrow ruling, and we just want it confirmed that the only financial net worth information that comes is this redacted version rather than the Lee's other entities, the Lee's other anything.
From the court's perspective, we only need to be dealing with this property and the claims made related to this property. I realize there have been some claims. There is Mr. and Mrs. Lee may have an entity that's related to this property, but that's all we're talking about. If they've got, if they own a landscaping company in Butte, Montana, that's not coming into evidence. And surely we ought to be pretty clear, and no one would expect it to. All right.
Judge, one thing that, and this may go to some of the tax records that Ms. Oscarson has discussed, but one thing that we did, we initially had evidence about it or testimony about it. I think it was from either Larry or Jerry Lee about how, and this may go into some of your rulings on damages. So it kind of goes under the umbrella, but that certain expenses of the cattle operation were paid for by and through Apollo Perforators, which is a company that the Lees have had and run for 35, 40 years in the Midland, Odessa area. In Mr. Brunson's deposition, their accountant, where we looked at both these, what we're calling the banking records or their annual unaudited financial statements, as you indicated, listing different assets for the bank purposes. There were also some Schedule Fs to certain tax returns talking about profit and loss on the cattle operation. And there were line items on some of those years, though not all of those years, reflecting some contributions to the cattle operation by Apollo Perforators. So, I think there's at least, going in and asking them how much money Apollo Perforators has made on a given year. I don't think we're looking at doing that, but to the extent that there are going to be allowed testimony or evidence about monetary damages to their cattle operation, I don't see how we can separate the Apollo Perforators contribution to that, and just wanted to add that clarification. And maybe Blair has something additional to say.
That's a good point, Mr. Burrell. Thank you for making that about Apollo Perforators. And then kind of going to the tax returns and the Schedule Fs and why we need that, because the plaintiffs have claimed, of course, damages with relation to their cattle operation. And so we need to be able to show that this cattle operation was not particularly profitable before or after the spill.
Okay.
May I respond, Your Honor?
Yes.
We have not asserted a lost profits claim. And I want to draw a very fine distinction, because I think Mr. Briel to some extent has a point. If but this is going to go to how we draft this language as opposed to whether or not there's even really a dispute here. If we, in our case, put on evidence regarding how other entities were actually involved with the nature of the harm and damages that we're going to present at trial, it would be fair game to some extent talk about that interrelationship. But to try to expand this out to suggest that we have a lost profit claim or that we have contended the ranch was wildly profitable and that's been damaged, that's just not a part of this case. But those all seem to me about drafting issues that perhaps plaintiff's counsel and the defense counsel should spend a little bit more time working on to just make sure that we're articulating in the way that allows them to do what they perhaps in fairness are allowed to do without going to issues that don't have any bearing on this case.
Okay.
Judge, if I can make a suggestion to shortcut it, as far as the representations that you're going to allow in, I think you've made your ruling clear. I think it would be reasonable for us to agree to a motion in limine, at least, maybe not agree they don't come in, but agree to a motion in limine that before we try to go into Apollo perforators or anything else, which I think is going to be affected by your rulings on some other things we're going to talk about. But we just approach the bench so we don't get in trouble. None of us want to try this case twice. So if the other defendants are okay with that, I'd just say we.
All right. Thank you. That is exactly the direction I'm headed in. What I think we need to do is I'm going to grant a motion in limine as requested by the plaintiffs, with the exception certainly of the redacted financial statements that were submitted to the bank. And then what I want y'all to have the opportunity to do is there may be other things that in the coming days, y'all say, we have an agreement, this would not be subject to that motion in limine. I would far rather y'all be able to have that discussion and then inform me in advance so I don't think someone has just waltzed all over the motion in limine. But let me know if there may be certain other things that y'all agree should be able to come in and would not be subject to the motion in limine. But then otherwise, it's a motion in limine. We'll treat it as such, approach the bench, handle it that way, and we'll keep moving. All right, so that should hopefully that will address both the issue of the bank records, but also y'all will be able to confer in connection with the tax documents and see what y'all can agree, through redaction or other means can come in that would not violate what the plaintiff's concerns are. And my sense is the primary concern the plaintiffs have is they don't want there to be all kinds of evidence that has absolutely nothing to do with this lawsuit or the facts at issue in this lawsuit about their assets coming in because it's irrelevant. So, all right. Now, what are the next issues? I think that takes care of those two on plaintiff's motion in limine. I will let y'all confer as to the others and see if y'all have language that works or is an agreement. I think Mr. Brown suggested that maybe we look at Memorial's supplemental motion in limine that has to do with the issue of damages. All right. And I have it here. I did not, everything was coming so fast and furious right before 2:00 that I have not had a chance to read it. So Mr. Brown, bring me up to speed, or one of the defense attorneys, bring me up to speed on the concerns that y'all have and clarification y'all need on damages rulings.
Well, I think the defendants all agree on what the damage rulings were, Judge. I think it's the plaintiffs who disagree on what the damage rulings were, but this is a little bit different subject. The court has previously ruled that the damages are either cost of restoration to the property to get it back to where it was before, or if that's not economically feasible, the difference in fair market value. All that comes from the Wheeler case. The Wheeler case also says that the measure of damages is a question of law for the court. What it does a very poor job of saying is when the court is supposed to make that decision. It does say that if there are fact issues that need to be resolved, then the jury needs to resolve those fact issues. It is our position there are no fact issues that need to be resolved. So here's some of the facts that we have. We know for a fact that Memorial spent over $2 million already to try and bring it to Railroad Commission standards. And we had a discussion the other day about whether that's enough or not, but to try and get it to Railroad Commission standards, we've already spent $2 million. The real estate appraiser's opinion in his report, I didn't take his deposition, I don't know if it changed, but in his report, his testimony was that the diminution in value of the property was about 1.75 million.
And is that plaintiff's expert?
As plaintiff's expert, Mr. Swanson. They have another expert, Mr. Gobb, and he has testified that to take it from where it is today to where it was prior to the incident would cost somewhere in the range of $654 million. Now, our experts have not given an opinion on that figure because our experts tie it to the Railroad Commission standards. And there's a fight about whether or not it's met those standards or not, but we don't have a contrary opinion as to what it would take to get it to the day before the accident. And we would just submit to you that there's no fact issues necessary. Assuming their testimony is true or anywhere close to true, that it's going to cost in the hundreds of millions of dollars to restore it to the pre-incident condition. This court can rule as a matter of law right now that that would not be economically feasible, which, by the way, their expert agreed with. He said, no, I wouldn't pay $653 million to fix this property. The property had a value of $4 million before the incident. Court can rule as a matter of law right now that the restoration is just simply not economically feasible, so that the damages that are available to the jury, to the plaintiffs, and the jury will have to resolve is what in fact is the diminution in value. There are competing estimates on that from the experts of various parties, but I don't think anyone disagrees that it's going to cost more than the diminution in value to get it back to pre-loss standards. This would have if the court did this, it would have another substantial benefit. We heard many times in the last hearing how complex the issues are with respect to Railroad Commission standards versus background levels, getting to background levels. And we've got hydrologists, we've got soil experts, we've got everybody that are going to testify for hours on end about these issues. If the court rules the issue is diminution in value, which I'm going to have to learn how to pronounce that word before this case goes much further, but if the court rules that's the measure of damages, all of that evidence goes away, and we're no longer probably talking 3 weeks. We're now talking who done it, what percentage they done it in, and what the diminution in value is. Simplifies the issues, and no matter what evidence comes in, since we've already spent more than diminution in value and they say it's not fixed, it's not going to be economically feasible to repair. So why not resolve that issue now and limiting out any evidence of cost of repair and limit the damages to loss in value?
All right. Any other defense lawyer and have any other aspect of that you want to hear, or is that pretty much sum it up for all of y'all? Okay. All right. Plaintiff's counsel.
Your Honor, there are at least two problems with that proposed approach. Mr. Brown alluded to the fact that in Gilbert Wheeler versus Enbridge, the Texas Supreme Court said that certain predicate issues have to be decided by the jury. He's correct. This is quoted in our response brief on page 2. The court wrote, "At the same time, we recognize that questions regarding the facts that underlie the temporary versus permanent distinction must be resolved by the jury upon proper request." That is important, it's critical, it's frankly dispositive for two reasons. In Mr. Brown's analysis, he completely skipped over the temporary versus permanent distinction. He leapfrogged to the economic feasibility test. We don't even know if we're in the economic feasibility test until we decide if the damage is temporary versus permanent. As a court defined in Gilbert Wheeler, if it can be repaired, it's temporary. If it cannot be repaired, it's permanent. If it's temporary, it's the cost of restoration. If it's permanent, it's the diminution in value, unless, and it's only when you get to that unless part that you get into the economic feasibility test. Because the economic feasibility test says if the factual predicate allows a court to conclude that the damage is permanent, if there is a diminution in value based upon the permanence of the damage, but the cost to repair so dramatically exceeds, or maybe I may be reversing this. It's actually if it's temporary and the cost to repair so dramatically exceeds the diminution in value, you're limited to diminution in value. You can't assume we're in any of those universes, Your Honor, until we have jury findings. So on the temporary versus permanent distinction, the Texas pattern jury charge, Your Honor, and we've attached a copy of our charge as Exhibit A and PDF page 34, there is a reason why the Texas pattern jury charges requires even that the jury be charged with predicate questions on whether or not the injury is recurring, repetitive, persistent, or, and I'm paraphrasing here, sorry, Your Honor.
Oh, okay, I've got your charge. You just said PDF page 34. I suspect that's your total filing. I have the benefit of where y'all broke it out for me. So where on what's the page of the proposed jury charge that I need to look at?
The actual pagination on the page, Your Honor?
It's on the proposed charge.
You will be looking at page 21.
Thank you very much. Give me 1 second to get there because I want to look at it with you. All right, you may continue, Mr. Knight. Thank you very much.
So this is question 10. This is taken from PJC 11.5 and PJC 12.4. And that, at least 11.5, I think, is just the omnibus, all-purpose, all-utility. Anytime you're dealing with damages to real property, here is the way, and it doesn't matter the cause of action. It's the species of damage. And that distinction is going to become important in a moment here. When you're in the real property universe of damages on any cause of action, here is what you have to ask the jury. So the jury can make the predicate factor findings for the court to then say, as a matter of law, it's temporary or permanent. And you ask these questions. Is it capable of being repaired, fixed, or restored? If the answer to that is yes, that means that it's temporary, and the court orders accordingly. But you can't just stop there, because if you answer no, then you get into the other issue. If whether or not the injury of such a character has to recur repeatedly, continually, or such a character that you anticipated recurrence will be only occasionally irregular, et cetera, et cetera, et cetera. That's the kind of predicate finding the jury has to make in this tiered approach for the court to make the temporary versus permanent distinction. We can't do any of that now. And the reason we can't do any of that now is Mr. Brown is correct. Our expert has opined that there are certain concentration levels in soil and in the groundwater to which the property needs to be cleaned up. And he demarcates each of those levels based upon the different standards. I think it's 500. I think one is 300. I think one is 150. But there's a dispute about that because the court may recall from our motions to strike Ms. Moore at minimum, I believe Mr. Wheeler as well, they're contending a different cleanup standard applies. So until you find out, the jury decides which of the two cleanup standards is right, you can't know whether or not it can be repaired. Because if it's this tiny footprint that they're claiming and we categorically disagree with is applicable here, perhaps it would be able to repair it under those standards. But if the jury agrees with us and we think that they should, that's only in the worst possible case scenario do you get into the monetary amounts that Mr. Gobb is describing in his expert report. But we don't know who the jury is going to believe. So we can't forecast or circumvent the role that the jury has to play on first resolving, okay, what is the appropriate cleanup level? Once we have the appropriate cleanup level, what is the effort that's going to be required to get to that cleanup level, to get through the first tier of this, temporary versus permanent? And then we have to go to the next level. If they say it's temporary, the jury's still going to have to determine, okay, what dollar amount do we actually believe as the fact finder is going to be required based upon the parties' respective arguments. And so maybe the jury does come back and say, okay, it's going to be 160 million or whatever Mr. Gobb put in his report. But maybe the jury comes back and says, no, I think that, this could be cleaned up for closer to 6 million, 5 million, 3 million. We don't know. Depending upon what the jury's answer is, that's going to be dispositive of the economically feasibility test. Because we don't know what the proportionality is between the diminution in value, whoever the jury believes on that piece of it, relative to whatever the jury concludes on the amount to clean up. These are all unknowns at this point, and only after the jury decides those issues will the court be in a position to then enter, as a matter of judgment, the appropriate temporary versus permanent categorization, and then the corresponding measure of damages found by the jury but entered by the court on both of those issues. And all of that, Your Honor, is reflected in the way that the Texas Pattern Jury Charge sets these issues up.
All right.
Can I respond briefly, Your Honor?
Hi, Mr. Brown.
What the Wheeler case says is when the facts are disputed and must be resolved to correctly evaluate the nature of the injury, the court, upon proper request, must present the issue to the jury. This court's already entered an order that says the damages are cost of restoration, or if cost of restoration is not economically feasible, then the fair market value before and after. We've already spent more than what their expert says a diminution in value is. No matter what answers the jury gives, it's not going to be economically feasible to repair this property any more than it's already been repaired. Mr. Knight said it could be 3, it could be 5, it could be 6. All of those would be economically unfeasible when it's in excess of what the reduced market value is. 6 is excess value. 4 and 6 are excess value of the property as a whole before the suit, before the incident. So any answers they give to all those questions, I agree that's how the PJC says to submit it, but you don't have to submit something that's not necessary. The answer is always going to be it's economically unfeasible. So the only reason to put this evidence in is to inflame the jury. There's not going to be numbers you're going to be having to award. It's simply they want to have huge numbers to inflame the jury, as opposed to going by the court's ruling, which is they get diminution in value if it's not economically feasible to repair the land.
All right. I'm gonna have to look at this one, guys. I'm sorry. I need to go back and reread. That was before I ruled on, we heard all the expert stuff. So I'm going to have to go back and reread that case and refresh my own memory on and look at my notes, how I ruled and why I ruled that way. So I will try to get y'all an answer on that, because obviously y'all desperately need to know which way to jump on that. So I will try to get that out to y'all. Are there other damage issues that we need to take up today that we can, other than this obviously significant one?
Your Honor, I think there's one other issue. I think it's been ruled on by the court. I don't think it's an issue, but in some exhibits the plaintiffs are proffering, they're still talking about the special damages, including the Herring Ranch and the cost to improve the Herring Ranch, which I think the court has granted the defendant's motion for summary judgment, but it still comes up in their limine. So we'd like to address that.
Right. Let's go into this. Whose motion limine is that in?
I'm not sure if it's in a limine, Grady, or if it's in their exhibit submission. And
It
it's
is
talked about in a brief.
Yeah, I'm sorry, plaintiff's exhibits.
Basically, it's this
107, 108, and 109.
All right, give me just 1 second to get those up here at the bench.
This one.
And 115.
On the rail right there. 108, 109, and 115.
Along with 107.
107,
It
108.
relates to our motion.
And Your Honor, if it'll help you, and if it doesn't, I'll just be quiet, but it's Granfield's motion in limiting number 18 and 19, where we just recopy what they're referencing in their pleadings and their discovery as the Herring Ranch damages.
Okay.
And
Just one.
Special.
Now we're about to. Okay, what numbers are those, Mr. Terrell?
Your Honor, it would be Granfield 18 and 19.
becoming 17 is basically what we just talked about. The ammunition.
18. All right. Okay. Who was the first one talking to me about this? Was it Mr. Brown? No, it was Mr. Brill. Mr. Brill.
Judge, I was only when Mr. Terrell started talking about on some of plaintiff's exhibit list, I was just trying to be sure to reference the exhibits on plaintiff's list that relate to the Herring Ranch damages, which I think as Mr. Terrell has now gotten his motion in limine paragraphs before the court, I think that they're tied together, but the court can look at Mr. Terrell's motion in limine and know that those four exhibits that I referenced, 107, 108, 109, and 115 are the exhibits on their list that all defendants have objected to that tie into his motion in limine that I'll now let him go ahead and bring to the court.
Let me do this. Let's go through this and let me just give y'all what my thoughts are on some of these things, because that may be the easiest. All right, number one, acquiring the Herring Ranch. We've got issues. I can see there being certain aspects of damages that go to temporary damages. And certainly, if they needed to move the livestock off the ranch, lease another place, the court has a real hard time with going and buying another property as a temporary damage. So that doesn't fall in the 5.7 million plus to buy another ranch. That doesn't really fall in. That's a permanent solution. That doesn't fall in as a temporary. It obviously doesn't go to the diminution of value. So from the court's perspective, that's not admissible. It doesn't fall into any relevant category for damages. So I'm sorry, who's speaking?
No, I was going to wait till the court finished.
Okay, go ahead, sir.
Yes, Your Honor. If we go back and we look at the order the court entered, the entire issue with respect to the Herring Ranch went to whether or not it was special damages, and the court ruled it wasn't. The first ruling, that was ruling B, the first ruling was with respect to real property damages. Here's the standard. Well, the place we part company with the defendants, and Mr. Knight's going to take it up in more detail, is not with those two rulings. If the court thinks the Herring Ranch is not special damages, and that term is defined by Texas law, we understand that. But we have a nuisance claim. We have a breach of contract claim against all the defendants under the lease that has never been addressed. Under that breach of contract claim, and Mr. Knight's going to get into the details of it, if we're successful, we get consequential damages.
But I granted their motion for summary judgment on the contract claim.
Mr. Madison misspoke. He meant Memorial. Memorial did not move for summary judgment.
On the contract claim, I apologize, Your Honor. I didn't make that clear. And in fact, at paragraph 234, page 31 of the fourth amended, we end our petition on our contract claim first count to say that Memorial's also breached the lease because they failed to protect the leasehold by the cleanup they performed. And so there's a contract claim still out there with Memorial that has never been addressed that's based on the lease. And under that claim, the Herring Ranch purchase may be consequential damages. Now, I'm not going to get into the details of that until the court wants us to, but in essence, the lease incorporates what are called implied covenants. And the lease, it's not us suing on the implied covenant because we're suing on a lease that includes those terms. So consequently, we have a breach of contract claim against Memorial. We are alleging they failed to protect the leasehold under one of those implied covenants that's included in the lease. And the Herring Ranch is going to be a consequential damage of that breach. Now, secondly, the court granted us nuisance claims. And there are damages involving nuisance that go beyond property damage. And cited in our materials are all these cases that talk about the ruling the court made in the summary judgment that we would be entitled to put on in Part 2A, Grandfield's no evidence motion for summary judgment on plaintiff's alleged damages for personal injuries related to annoyance and discomfort is denied. So we have a nuisance claim. We get to put in annoyance and discomfort. Our people are going to testify that the nuisance was so bad for all kinds of reasons. They had to move these cattle and they went and expended this money. Now, that may be a little different than the contract claim, but the contract claim is locked sure. The Herring Ranch is a consequential damage. That is pleaded in the petition. And there are other arguments, but just at the threshold, we disagree with their reading of your order. They ignore all the things they didn't move on. And then they interpret this to encompass all of those. And it just isn't inclusive in that way. Memorial has no issue and has no right to exclude the herring damages in light of our breach of contract claim. There may need to be an instruction that only goes to one claim or the nuisance claim and may not go to Ivory or Grandfield. But as to Memorial, that claim is alive. It's never even been raised. Thank you.
And thank you for reminding me of that Memorial's motion for summary judgment was more limited than the other defendants because that had, frankly, as I sat here on this issue, had slipped my mind. I was looking at it only as to the tort damages. So thank you. I do appreciate that, Mr. Addison.
Can I just respond briefly, just let the court know, I'm frankly not sure why we didn't move on the contract claim, but we're preparing some briefing for the court. We don't think there is any contract claim here. We certainly don't think that consequential damages can be awarded that are so unrelated to the property. This is like we wrecked a $5,000 car and they bought a Bentley. So consequential has to be reasonable. The only contract they have limits consequential damages. So this is a red herring. There's no, the only contract is the surface use agreement, and it does not provide any implied covenants. The cases they rely upon, the implied covenants are for damage to the mineral estate. The damage to the surface estate is simply tort. It's negligence or trespass.
Well, Your Honor, number one, that certainly demonstrates this issue's never been raised by Memorial because they're saying it hadn't. And just in case the court's interested in the lease, which is the lease that governs every operator, including Memorial, at paragraph 9, it says expressly, all express or implied covenants of this lease shall be subject to all federal and state laws, executive orders, rules or regulations, and this lease shall not be terminated in whole or in part, nor lessee held liable for damages for failure to comply if compliance is prevented by certain acts that haven't occurred. And so when you look at that, it expressly includes the implied covenants. There are 3 implied covenants in Texas, one of which the classical one of which is to protect the leasehold. There is a case that was decided on this very point, the Amico case. And in it, it basically holds anything the operator does that causes harm does not protect the leasehold. Okay, let's stop there. All we get to here, they can go challenge it. We recognize that, although they haven't, although everything now they're filing is untimely if it's asking for relief. But the point is, we're suing on a lease that incorporates the implied covenants. So it's a breach of contract. If it didn't mention that, if it only said all express covenants shall be subject, we'd be having to sue under the implied covenants themselves, which is a little different. Not here. We have a lease between the parties. It governs their ability to be on the property. It's the lease that contains the language, you hold the lease by producing. This is the governing document. And it says the implied covenants apply. It's in the lease. We say they breached it. We may lose that, but they don't have any ground to exclude that as we sit here today because they have no pleading challenging it.
We do have pleading challenging the contract claim, Your Honor. The Amico case, again, is damage to the mineral estate, and the covenants run to damage to the mineral estate. The surface estate doesn't have implied covenants. It's simply going to be negligence and trespass.
Well, one other point, Your Honor, before I leave it. The nuisance case, and Mr. Knight's going to take it up. I don't mean to usurp his argument, but it's unequivocal for over 100 years. Under nuisance law, you recover this property damage calculation we're talking about, whether it's real property or real property damage under nuisance, and that even if you don't have a property damage claim, you have the right to put on your nuisance personal injuries of discomfort, annoyance, and the like. And the notion that it doesn't, quite frankly, is not supported by any good faith position. For 100 years, that's been the law. You look at Crosstex, it's the 2017 case, it addresses it. So I'll leave the rest of that argument to Mr. Knight, Your Honor.
I never mentioned the word nuisance. I didn't say that the annoyance damages aren't recoverable in nuisance. I was responding to the contract, and I'll just shut up because I've talked too much.
Okay. Obviously, here's what I want y'all to do. Y'all probably need to look in connection with this motion in limine by Granfield. And the issues that everybody's got is y'all need to go through and look at each one of these that's listed. It's in the plaintiff's petition, but it's also in Granfield's motion in limine number 18, and identify, are all of these damages claimed by the plaintiffs against which entities under which cause of action? I think that's frankly probably would help clarify this issue for everyone. And it would be very helpful to the court to be able to see, but I think that's probably what we need to do instead of trying to go through
and 19
right now is y'all figure that out. And it maybe that's a burden I'm throwing on in the plaintiff's lap, and I'm sorry, but where do you think you get to claim these specific damages as to these specific causes of action?
Yes, Your Honor. If we have much more of this, we may send you back to criminal law. You may want to retreat to criminal law after dealing with us.
I may start trying divorces again. I quit that for 30 years, but.
Well, tomorrow is all day criminal. So it'll give me a little bit of break. These are obviously issues that y'all need rulings on. I'm just trying to figure out the most efficient, frankly, y'all's time, because y'all have so many things to do. That's what I think might be the best, because I think once that's delineated as to which damages are the plaintiffs claiming against which defendant on which causes of action, then y'all are able to really see what's coming in or not. And it will frankly may help us get to a point that y'all start being able to figure out how in the world are you going to argue this to a jury in a way that they know what damages you think about for defendant A versus defendant B, because that is going to be tricky. So,
Your Honor, may I make a suggestion
yes, sir.
to actualize upon that view, which is what, frankly, I think Mr. Addison and I have been contemplating. Perhaps it would make sense for us to take the pattern jury charge and under the different subcategories of recoverable damages per cause of action, which are separated by defendant, we would just pinpoint to the court, Your Honor, we think that under this sub element of damages, the following expenses would be admissible. Do you think that perhaps might be?
I think that would be helpful. I think it'd be helpful for y'all. I think it'd be helpful for y'all to be able to have that to work through with defense counsel. Y'all may find there are some things that you agree and go, oh yeah, you're right. But there are so many moving parts for all of y'all and different claims against different defendants. I think that would help with a roadmap for the court and also clarity for the parties. And then if we've got things that then we need to fight over it, I know which defendant needs to fight over it and which defendants don't have a dog in the fight.
Your Honor, since the court's going to be taking this creature we're creating and using it, do you want it to be annotated in some way so that you have the authority, or how do you want us to present that portion of it? Do you want to rely on the materials filed, or what would be most helpful?
I will rely on the materials filed. That's if there's something else you want,
It's just us and I.
fine, but otherwise, I'll rely on the materials filed because, I've got all of your briefing on these issues. It's just a matter of trying to figure out a way that we can work through it the most clearly and cohesively.
There's one other suggestion, Your Honor. In light of this, please tell us the soonest time you would like it, and then let's make it sooner.
My thought would be, y'all want rulings out of me before, y'all tell me, how fast do y'all want a ruling on some of this and clarity on your damages evidence?
I'm going to say
yesterday.
Plaintiffs and defendants, the Herring ruling is huge. It's big for them. It's big for us. The notion of what our claims are and the ones that can all be asserted is in the same level. I think those two stand out amongst all others that we're talking about. The clarification or understanding of the order on Granfield, and then the issue of the Herring damages. The defense may have others that are more meaningful to them, but those two stand out to us.
Okay, so Herring damages, and then the order, you just mentioned the order on Granfield.
Well, the order on Granfield summary judgment, the defendants take to apply to everyone for everything. And we don't read it that way. We read it as something you thought about and checked various blocks to reflect what the law was. And so we think there's a nuisance claim. We think there's a breach of contract claim, that sort of thing. We recognize the Herring ranch is not a special damage under the court's ruling, but that doesn't tell us about personal injury damages, consequential damages under a contract. And so it's not all encompassing of Herring, although the defendants tell us it is.
All right.
Or have been.
I will do this myself. I will get plaintiff's fourth amended petition, and I'll get the summary judgment motions, and I'll get the summary judgment orders, and I'll go through and see what causes of action I think are still left in it. And I'll work on that this evening so that I can then see, and maybe what I may end up doing is shooting y'all an email and saying, I think these are the causes of action that plaintiffs still have against Granfield, and that they have against Ivory, and they have against Memorial. And that way we've got clarity, because there are some differences. I remember there was one thing in particular, I don't remember exactly which one it was, but that Ivory did not move for, the Granfield moved for. And so there's a cause of action still outstanding as to Ivory that I granted as to maybe Granfield and Memorial. And so I will look at that, because I was working through all those issues to try to see what in the world is what. There's a lot still left, but what all is it? So,
well, Your Honor, do we understand that's something that's going to occur in addition to this using of the patent jury charge to present the claims and the like?
I'm going to go through with just a hard copy of y'all's petition and frankly mark out, this is in, this is out, this is in, out as to this defendant, so that then I can come up with a list and I'll send that to y'all so we can see if we're all on the same page as far as what claims that we don't hear in the background.
I'm
So
sorry, Your Honor, you broke up on about that last 3 sentences about after you're going to look at it, you were going to share it with us.
yes, I want to share it with y'all because I want to make sure that we are all on the same page about what causes of action I think are still on the table. And then that will give us, then we'll know from the damages aspect, which damages are coming in under which cause of action.
Your Honor, I don't want to sound like a broken record, but I can assure the court I made a very earnest effort in our proposed jury charge to set it up that way. I excluded certain defendants from certain causes of action. I included certain defendants. And so maybe that could be a cheat sheet for the court to make your life a little bit easier. You can tell me where I'm wrong and where I'm right, as opposed to trying to reinvent the wheel.
No, that is great. I saw that you have submitted one. I was pleased to see it was only 30 pages long because I was really a little bit fearful when someone said it was 160 pages. I thought that was a joke last week, but I thought, Lordy mercy. All I could think was, guys, I have to read it to them. So, okay. So that's the first order of business. And that may be what y'all need from me quickly, is some information on that. And then let me look at these damage issues. What else, if anything, do we want to address today?
I had a fairly non-significant question because I can't recall if we discussed it. Will we be allowed to wear the face shields or the mask, or is it both, or is it only one? I just wanted to be sure I was clear on that.
Here's what I've done in other trials is counsel will come in with a mask on and you will have a clear shield. When you are seated or at a stationary position, and we do have a podium that y'all will be able to use for voir dire, you will be able to take your mask off so that the jury can see your face. When the jurors once they're seated, they will be able to take their masks off, but they will have to wear their shield. Now, there may be times if we can't hear someone, we may have a moment where I have to say, would you pull that shield up for a second, answer the question, and pull that shield back down. It's a balance between being able to hear and y'all being able to hear and Ms. Wilde being able to hear versus public health, but we'll try to do that as quickly as possible. The objective is when you're moving around, I want people to have a mask on when they're walking around, and those shields don't give enough protection from airflow in and out of the shield for public health reasons. Now, when let's say Mr. Terrell is voir diring the jury, I would expect counsel to all be seated and you can have your shield on and your mask off because you're sitting right there. We'll have y'all distanced by table, so you'll be able to do that and you're not moving around. Then when you're presenting evidence, once we get to the actual trial, then counsel may wear a shield. We'll see how the acoustics are going. If we've got enough distance in there, which I think we're going to, what I may make a judgment call on is I may let the witness sit without a mask or a shield, because otherwise you're trying to get the microphone up into the shield. It's a real mess. It's an echo. It's a hot mess. And so my thought would be that counsel asking questions would be allowed to take off a mask and a shield. Witness would be allowed to have no mask and no shield, and we'll put microphone covers on and everyone will be distanced. Now, if you're going to approach a witness and stand there for any given amount of time, I will want counsel to probably mask up and you'll just have to speak up. I mean, I know it's awkward. There's no hard and fast rule. We, in a lot of ways, just have to kind of figure out in circumstance to circumstance, what's the best way to handle it. Everything will be much easier once we get past voir dire and we have fewer people in that courtroom. And then at that point, I will let jurors make a decision if they want a mask or if they want a shield. They will have to wear one. They won't want to wear either. I'll tell you all that right now. They'll be mad at me about it. It's okay. I won't let them hold it against y'all. But they can choose. Everyone hates the shields. universally, they hate the shields. What we've seen in other trials is they wear the mask. They would far rather have on the mask than have on that shield. You lose some facial expression, but you at least get the scrunched eyebrows. If they're frowning at you, I've been told that you can tell if I'm smiling or frowning or glaring based upon my eyes even with a mask on. So there you go.
Your Honor, I hate to ask a personal advisory opinion of the court, but it won't stop me. I've never worn a shield. Apparently you have. Are they cumbersome and do they stay in place and the like?
They are. Cindy is off camera. She hates it. We hate it. You won't catch me with one on any longer than I have to have it on. They stay in place, and I will bring some. I need to double check as to how, help me remember somebody to count our shield count here, because I bet I have to take them. I wish I had one. Tanya, would you go in? Can you get in Renee's office? Yeah. There is a box in the closet in Renee's office that just says 51st. That is full of shields. If you would drag that down, I will show these guys. Basically, you look like John McEnroe with a headband on and then this plastic thing in front of your face. It's a look. Mine's red, white, and blue. Y'all's will be blue and white. Mine's a little heavy duty. The others are fairly thin. And, what I really hope is that once we get into the actually meat of the trial, y'all will be able to just wear your mask and pull that shield off and not have to wear the shield, because there is a bit of a glare, and you'll be able to just take the mask off when you're asking questions, put the mask back on when someone else goes to cross.
Thank you, Your Honor.
You're welcome. And if we get that in before we finish, I will show it to you. I will tell y'all right now, I have not counted, but we have rather extraordinary responses from our jury. We will have more than enough people present, I believe, to impanel a jury. I don't know if y'all have been looking at the questionnaires. I've started going through them. There are some who have put in the question that was about, is there any personal reason that the 3-week trial would be a hardship for you? I'm looking specifically at those. There's going to be some that I may go ahead and excuse. I want to see exactly how many I have who are not claiming any type of an excuse, but we've got plenty that have asked to be excused due to health concerns, or they're COVID vulnerable, or other reasons that I've excused. But on that question, if there are some, for instance, I think there may be a couple of people who they have a medical procedure, or they have physical therapy twice a week, things that would really truly be a hardship for them. I'm going to probably go ahead and try to eliminate some of those folks before Monday, so that we really have people who understand the responsibility to report and serve. There are some who want to be off simply because of work. I don't tend to grant those, because it's everyone's responsibility to do jury duty. But I'll take a hard look at that, and I may bring them in, and then those may be people that once we hear from them, we excuse them during the process on Monday. But we will go from there. My hope also is that, thank you very much.
Oh,
Right.
Oh boy.
Oh, yes. That's what I mean. I mean, it is. Now this one has let me see. There's a piece.
Earth to the court.
I know. It's lovely. There's a film that you pull off. I have it here. Let me get my fingers on it somehow, and it makes it a little easier.
With these shields on, the jurors may think we're dealing with plutonium rather than chlorides.
I think we lost the judge.
Yeah, I think we have, and froze up.
Two judges now.
Muted, Judge.
All right, we just had a thunderstorm roll through and my computer died. In any event, this has a film that I've now removed that makes it a little easier. Not much. Can y'all hear me and see me?
Yes.
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 Yeah, it's not fun. What'd you say, Cindy? Oh, I can't hear them. I have the audio down. Okay, hold on. Exit full screen. Tanya, would you go up and turn off the volume on that computer? I think it will be down because I got completely kicked out. No, we may get a screech. Okay, someone say something. Let me see if I can hear y'all.
Can you hear us on this end?
Yes, yes, we can. All right, Cindy, can you hear it all? Okay. Are we to matters that we don't need a record for anymore?
As far as I'm concerned, yes.
I think so, Your Honor.
Okay, all right, good. Cindy's in good shape then. Okay, so that's what we will do with regard to masks and shields. And, you know, we'll take it as we can, but hopefully by the time we get to trial, like I said, we are spread out enough. That courtroom is really quite large. And so hopefully we will be spread out enough that y'all will be able to remove that mask and talk to, and certainly for closing argument, I'll let you remove your mask and argue the case. That's what I did in Sterling County and it worked fine. I will take my mask off when I'm needing to read portions of the charge. Otherwise I'll have it on and I'll deal with fogged up glasses and whatnot, just like all of y'all will. Jury. So my plan on, I have temporary orders, family temporary orders on Friday morning. I'm actually going to go to Robert Lee Friday morning and conduct my court hearings on Zoom from Coke County so that I can assess the courtroom and see how everything's set up. I will try to take some photographs and send those to y'all by email. So you will see it. I think Mr. Brown, the gentleman who's coming to handle the televisions and monitor, I think he is planning to go tomorrow based on what the district clerk has told me. Is that your understanding?
That's the last conversation I had with him. He got
Okay,
beat into
excellent.
it by Munch Hart.
Okay, excellent. Okay. So I think he's going tomorrow. I've asked the district clerk's office to let him know the tables where they are currently positioned is not where they will be, but that's where they will be for evidence presentation, but we will need to move some tables. We'll shift to where y'all can face the gallery for voir dire. There will also be a couple of spots you might let him know. Just be aware where the 14-person jury box, the traditional courtroom jury box is. That is the side from which the jurors will enter and I will enter. And so we probably need to not block my ability to get in the courtroom. That would be helpful if I can actually get in, but just let him know, you know, that may not be able to be in a permanent position right there. He may have to see how we're all seated in order to figure out where to put things.
He's done a lot of these, Judge. Every cord will be taped down, so there's no trip hazard, hopefully.
My main thing is I don't want to be having to do the shimmy underneath the television set to get into the courtroom.
He's very good at what he does. I think if it needs to be changed on Tuesday when we get there for the actual trial, he can make it happen.
Okay.
Or stay late Monday to revise whatever is done Thursday.
Okay, excellent. I'm going to work with our district clerk so that y'all will ultimately have a list. We have a list of an idea of who all is showing up and what their original number was, because that's what all of your notebooks and all those questionnaires would be tied to. You'll have their original number and then you'll have what their seat number should be. If we have more than 100 people, unless there's an objection, I'm going to cut the remaining people from the list and we'll use the 100 that we have questionnaires on that we anticipate are reporting and are qualified. Does that
Your Honor,
work?
as we've said before, we consent to this method of jury selection in light of all the unusual circumstances associated with COVID and people's concerns. And so we are comfortable with the court doing all of that. I do need to mention one other thing. My two elderly clients, one of them has a difficulty urinary tract issue, and she has to periodically leave. And we're working on, I think they're seated at the best place for that, where the court has discussed it. And we're working on a way to get that handled with the least intrusion or disruption. She either will be in a wheelchair, I've now learned, or we'll have to have someone help her. But we'll set all that up when we get there and make it as unobtrusive as possible. But I did want to mention it.
Okay. There is a side door out of that, what would be the 6-person jury box.
Right.
There's a side door that goes directly out. It goes through the county attorney's kind of a little hallway vestibule, but I'm confident we can make that available so that she can go in and out that way into the ladies' room and then come back in without having to cross in front of counsel or through the jury to leave the courtroom if she needs to.
Right. I thought that was the configuration. I think it's as ideal as we could have for that. Thank you.
All right. Very good. Anyone else have questions for right now that I can answer about just the process that we'll go through on Monday or trial?
When are we starting Monday again for sure? Dawn?
We are planning to start at 9. Now, that's what time I've asked the jury to report is at 9. I plan to be there at 7:30. And what we should do, I think I did let y'all know that the jury room is large enough. I had forgotten how big it is. They will actually adjourn to the jury room once we have the jury impaneled. They will be coming in. If we need to take anything up that morning, we will probably do that in the jury room. And so if y'all could be there maybe by 8:15, I think that would be helpful. And then if we don't need to address anything, y'all be able to go on out to council table. But we can address anything at 8:15 that morning. And if an issue comes up that we need to have more of a full hearing on, I may tell y'all to be there earlier. But right now we'll plan on 8:15. I will get there about 7:30. And then the jury is to report at 9. They will likely start showing up about 8:30. But we're starting later that day because they have to get that polling place open. And I will tell y'all, of our 3 members in the clerk staff, 1 has to run the election polling place in the court building for early elections. 1 may be out. I don't know which one may be out, but probably our district clerk is running the polling place. One of the other clerks may need to be out due to an impending death in the family. And then we'll have Jennifer Burdette, who will be helping with checking jurors in. Renee and Irene will both be there Monday to help check jurors in.
Right. Thank you.
All right.
Your Honor,
Answer right now. Yes, sir.
I have one other, just as this has been coming about, is kind of racking my brain about, I know you're not going to grant something like this, but I think for the record, I may have to file a motion for separate trial regarding the segregation of damages and how they might affect Ivory and Granfield on one hand, a memorial on the other. I know that's problematic, but I'm just trying to think in terms of how that evidence could be segregated with the jury for Granfield and Ivory, and certainly then how it would affect prejudicially Granfield and Ivory with these other special damages, contract damage, consequential or whatever. Anyway, I know I don't need to worry the court with that, but I didn't want to just bring that and say, I know you're not going to grant that, but I may need to assert it anyway.
Your Honor, that actually reminds me, Memorial filed a motion to bifurcate on the exemplary damages issue.
Yes.
We have not yet taken that up. I don't think the lead plaintiffs are opposed to that. So we perhaps.
Your Honor, I think we're going to withdraw that. I don't like bifurcating, so we can just try it all together and unless another defendant wants to bifurcate it,
Your Honor, my recollection is the court actually took that up and entered an order bifurcating the trial. I forget it. One of our many recent experiences together.
You're right.
And Mr. Brown had made that clear to me before now, I want to say. And so I have known about that. We haven't figured out our position on it, but we'll do so. I didn't know if they were really going to move forward with that position, unless the court thinks it has to be bifurcated or something.
Well, no, what I had done was when the motion was filed, I did look at it. It's a shall. And so I had no option. So I granted it. I think I've signed the order. I know I granted it in open court. And so it has been granted. Now, if the parties at some point in the next few days want to try to do something different, y'all can certainly file something and we'll address it.
Well,
Okay.
I think we can all agree it would shorten the trial.
It would, but y'all discuss that. I don't know if the other defendants have a position on that or not. And so if y'all are in agreement, it is completely fine to let me know. And I think if everyone's in agreement, we can undo that. But I think as long as it's not all agreed to, then I think the order has to stand. So why don't y'all confer on that and let the court know?
All right.
Okay. All right. Anything else y'all want to address right now? Otherwise, I'm going to go start drawing charts on people's proposed jury charges.
Thank you, Your Honor.
All
Well,
right.
actually, just one other thing we've not addressed, and just want to find out when we're going to do it. So it can be, we talked yesterday about what witnesses are coming live, which ones are not coming live, so we can try and limit the deposition objections
Yes.
that may need to be heard. I don't know if everybody's filed their objections or not, frankly. I'm having trouble reading my notes. We might need to get a heads up as to what witnesses may be coming the first couple of days. So if one of those witnesses is somebody that needs to be edited and subject to the court's ruling on certain objections, we can get that done so we don't waste the jury's time.
Certainly. Anything we can do to expedite this, I want all of us to do. And so y'all probably, that's one of the things, y'all don't need me for that to figure out what order, but y'all need to start working on that so that everyone has an idea of where we're going.
All right.
All right. Excellent. Okay. Then I will go to work. Y'all go to work. If we get other motions filed, we'll try to figure out a way. Just be advised, if we get other things filed, it may be late Friday afternoon when I have to hear them. If it's not going, or possibly Saturday. So if you really need a ruling, I can probably get it out. You may get me out of some movie my husband wants me to go see. But I'd like to get as much wrapped up so y'all have as much finality as possible. I don't know. I don't even know what it's about, but he's probably watching right now and he's irritated.
The new James Bond.
The new James Bond. Yeah, exactly.
Every war movie I go to, he has to go to a chick flick. That's all I have to say. So anyway,
Okay.
All right. Y'all all have a good evening. Get you some caffeine. I know you're all going to be up all night, and we'll all be back in touch. Thank y'all very much.
Thank you, Your Honor.
Thank you. Your Honor.
Judge.
Yes. Did someone else have something they needed to raise? Okay. All right. I'm sorry. All right. Everyone have a good one.